Miami's Community News. Our guest today is Laura Kelley, and she is an immigration attorney in Miami, Florida, but your office is in Doral, but you serve all of Dade County.
Yes, all of the world,
Right?
actually.
That is amazing. In immigration, because that is on a federal basis, right?
Mm-hmm.
That you have that ability to serve everybody.
Mm-hmm.
So in South Florida, across the country, there's big deals going on with changes in this administration's policy. For us in particular, we have the TPS for Venezuelans that are here in Miami-Dade County, plus all over. Plus, we have a large Haitian population, which has been added at TPS also.
Yes, correct. Since 2010.
And so now this administration said, we're going to change it. So let's talk about the Haitians, because it seems as though, if I was reading it correctly, that their extension that they were granted has been shortened.
Exactly.
So when is that deadline for them to leave? Is that what that is? How does that work?
That is the deadline where they will lose their temporary protected status. That is not necessarily the deadline in which they need to leave.
And what is that date?
August of this year.
March, April, May, June, July, August.
Yes.
6 months.
Mm-hmm.
Tell me about what's going on in the Haitian community now.
Well, I think it's the same thing that they were experiencing in the Venezuelan community, and frankly, all immigrant communities. They are angry, they are scared, and looking for what their next options are.
So what are some of their options? Because the Haitians here in Miami have made a huge, huge, huge difference, right? And I look into the medical arena, huge numbers of people working in hospitals and doctors' offices, plus they have ongoing businesses. And by the way, our most excited person that comes into our studios here is the Haitian women. Mm-hmm. They are just so excited and happy that somebody has paid attention to them.
Yeah. Hard workers, contributors to our community, part of the fabric of our community. Absolutely.
And just to make it clear, these are people that came in through the front door, they got the papers to work, and they're active in our community on all levels. And that right to stay here has been was shortened by 6 months or so.
Mm-hmm, that's correct.
So what happens now?
I want to say that there's this misconception that everybody who has TPS entered lawfully. That's not necessarily correct. Many people did, but not everybody who has TPS did enter lawfully. Once TPS is granted, it covers everybody who is here who is eligible. And I think it's really important to point out that in order to be eligible for temporary protected status, you cannot have any serious crimes, including misdemeanors. So not even a DUI, which I would consider that quite serious. But what I'm saying is these are not people who have any criminal history whatsoever. As to what happens next, it really depends on a case-by-case status for each individual. There are some TPS recipients who have removal orders. So perhaps they applied for asylum in court and that case was denied, and they appealed and that was denied, and now they have a removal order. When they lose TPS status, they will be at immediate risk for deportation.
So do you think this administration is going to have people go out and seek out those people that have lost their cases and there's a removal order for them? Do you think that's the way it's going to happen?
Absolutely. That's what they've been doing. And we've seen that. I saw an article with video from a man in Coral Springs where he exercised his constitutional right not to open the door without a judicial warrant. And they came back with a squad of armed agents to his home because he had a removal order. Again, no criminal history, U.S. citizen children, family members.
For one person? One
person in his home in a gated community. Yes.
When you hear these stories, it must crush you.
It is devastating. It is heartbreaking, but it doesn't crush me. It makes me want to fight harder. It makes me want to fight for these individuals. I cannot allow myself, none of us can allow ourselves to be crushed by this administration because that is what they want.
Yes.
They want us to give up.
Yes. And we see that. Let's talk about it on the Venezuelans. In Miami, more or less, how many Venezuelans are here?
Oof, I would say at least 300,000.
So generically, are the Venezuelans here, are they under TPS, or are they here and have all the documents they need?
I think it really depends. I couldn't say the exact numbers, but we have a large number of Venezuelans who are U.S. citizens or lawful permanent residents, or also maybe here under some other type of visa, such as a H-1B visa or an E2 visa through if they have a double nationality, for example. And then, of course, you have the TPS recipients or people who are have a pending asylum case. So it really runs the gamut. It's hard to say exactly what status each individual has, as far as I'm aware.
So Doral, your office is in Doral.
Yeah, and my home for over 10 years.
Okay.
Yeah.
And about 40% of Doral residents are Venezuelan. Do I have that figure right, more or less?
I believe so, yes.
That's must already be disrupting the flow of life in Doral.
I think right now, people are looking for options. I certainly know that it's given a lot of people in the community the passion to speak out and fight back. But as far as disruptions, in terms of businesses or anything else, I'm not quite seeing that yet. Again, there's still time. The first round is in April. The second round in September.
When you say the first round, what does that mean?
The first round of people who will lose their TPS status.
And this administration knows where they live and knows where they work.
Absolutely, because they all have work permits, and they have their social security numbers.
This month, you mean in 6 weeks?
Yes, essentially.
Are they going to? Cops, whoever, they're going to go out and pick them up?
Absolutely. If they have removal orders. If
Yes.
they do not have removal orders, they still may be picked up and detained and put into immigration court proceedings. It depends on how long they've been here. So if anyone has been here for less than 2 years, then and which is unlikely for a TPS recipient, because that 2023 extension that expires in April, that would have already been that they've been here for 2 years. So they are not at risk for what's called expedited removal. They still have the due process rights to have their cases heard in court if they do not already have a removal order.
And let's talk about visas. People that have the visas, people that work in the fields or in offices, cleaning up homes, or maybe on work sites. What's going on with people with visas right now?
I think that everybody is wary about when the next shoe is going to drop, because the administration is basically acting outside of the bounds of the law. I always like to say we are a nation of laws. We believe in law and order, and yet this administration is not following the correct procedures when they do things. And so, is it possible to cancel people's visas? Why not? They've canceled this TPS extension before time, which is unprecedented. Unprecedented.
Two different people told me about in Homestead, Redland area, that the police are stopping people asking for their visas. Have you heard that?
I have heard that, yeah.
So let's say they show them their visa, and let's say, is it a good visa that's here for a while? But what happens if they show them a visa or don't show it? What occurs?
Well, if somebody has a non-immigrant visa, they are required to show their documentation. They are required to speak to agents, unlike people who do not have legal status. They do not have, they have the right to remain silent. But part of the agreement one makes when they have a non-immigrant visa is the agreement to follow, that they will answer questions regarding their immigration status. But if they do have a visa that is lawful and they're driving lawfully, then essentially nothing should happen to them because they're lawfully here under a visa. If they're driving without a license, for example, or they're caught driving intoxicated or anything like that, then they can be detained. But usually what happens is they would be arrested for that crime first and then detained by immigration.
We've heard plenty of police chiefs say, we're not going to enforce the federal law. Is that going to hold? Or are they going to sometime in the near future be deputized to do that?
Well, under the latest law that was signed by Ron DeSantis, they are deputized to act as federal agents, essentially. But every single action this administration is doing is being litigated. So again, we still have the separation of powers and the power of the judiciary to push back on things that are not lawful. And so there are lawsuits. So law enforcement officers who refuse to abide by this state law now will have the opportunity to sue in order to not do that.
I was reading in the Miami Herald the attorney that's been handling the Haitian situation for 15 years. Was it Ira?
Ira Kurzban, correct?
So he's been involved in this for at least 20 years or 30 years.
Possibly more than that.
Yeah.
Mm-hmm.
We were just kids when he started. He's a real vocal person about that, and he made a statement: we were going to sue.
Exactly. Right? Yeah.
And so, people that are in the immigration arena, what is it that you realistically can do when somebody walks in your office and say, "Listen, I'm on TPS, and here in April, I may be the first ones to be called up." What can you do for them?
It really depends on the case. If that individual is afraid to return to their home country, we may be able to file asylum applications for them. And again, if they do not have a removal order, we could file an asylum application affirmatively with USCIS. If they are ultimately detained and then that case would go to the immigration court rather than USCIS. So it's not affirmative. Now it becomes defensive. And they may also have family members that can petition for them as well. So it really depends on the individual cases of these people. However, if somebody comes to me, they have TPS and they have a removal order, there's very little, if nothing, that we can do for them.
So let's say, Laura, so somebody comes to you and they go, here's my case, and you would take it and you would go to court. The judges hear this more or less the same story almost all the time. Is that correct?
Yes. And the court in Miami, the immigration court in Miami, has about a 97% denial rate for asylum applications.
So when you tell that to your clients or prospective clients, what's the look on their face when they think there's a 97% chance I'm going home or somewhere else?
Despair. But also, because there's a tremendous backlog in the immigration courts, and I heard that the Trump administration fired 40 immigration judges in the last 2 weeks. It may be a long time before their case is ultimately adjudicated. So there may be another administration before their case is adjudicated. So, sometimes the tactic is to delay. And that's what we can do for them, yep, is to delay the inevitable.
And we see that all the time, delay, and then things change and the file gets lost or the witnesses disappear. And finally somebody on the other side says, I'm done. Just whatever. So think back about 10 years. Did you ever think it would be like this?
Oh, no. 10 years ago, when I began practicing law, it was under the Obama administration, and we had prosecutorial discretion, which meant that individuals who had removal orders, who had no serious crimes, who had U.S. citizen family members, we sent them to ICE to get their order of supervision, to get their work permits so that they can further contribute to society. We had DACA that was approved so we could help dreamers when Congress refused to act. We had one of the things that the Obama administration did that a lot of people don't know about, but in 2013, they created a policy that people could wait for their waivers here in the United States rather than leave and be separated from their families. So that means when somebody is here and didn't enter lawfully but is now married to a U.S. citizen, they're not actually allowed to get their residency here in the United States. They have to go abroad to get it. And there's a punishment. It's called I'm going to say in Spanish, it's the 10-year bar. If someone's been here for more than 1 year without lawful presence, if they leave, even if it's to get their residency visa, they're barred from re-entry for 10 years. This was passed under the Clinton administration, by the way, in 1996. Mm-hmm. And so there was a waiver. It's an I-601 waiver that they could get, but they could only get it once they left the country, went to their visa appointment, were denied their visas, and then they could apply for the waiver. And then once they got the waiver, they could get a new visa appointment and then come here lawfully as a resident. That would require years of separation from their family. So the Obama administration said, that doesn't make sense. That's really keeping families apart. So let us go ahead and let them wait for the approval here in the United States. Let's get that approval ready to go before they leave the country. So now my clients can go with that waiver in hand when they go to their visa appointment so that they can re-enter the United States as a resident without being separated from their family.
Okay, let's talk about birthright, if you will.
Yes.
All right. The law is that if the mom comes here and the baby's born here, if the mom's not documented or not documented at all, or maybe it's documented, that child is born here as a U.S. citizen.
Yes, that's what the Constitution says. Yes.
Yes. So this administration tried to change that. What happened?
Well, they were blocked by federal courts and immediately blocked by federal courts. And the first federal judge that heard that said that this was blatantly unconstitutional, which it is, because the executive branch, the president, cannot change the Constitution unilaterally. And that's what they're trying to do. The 14th Amendment is very clear in what it says, that all those born in the United States, subject to the jurisdiction thereof, are citizens of this nation. And the only people that are not subject to the jurisdiction of the United States are diplomats and the children of diplomats. That's it. That's the only exception.
All right, so let's talk about the dreamers. If you would clarify what it is and how they get to that status and what it means.
So there's dreamers are, I would say, the larger group of individuals who came here as children. So they came here through no fault of their own and are here in the United States. And even if they entered alone, a minor cannot be held culpable for their conduct. And certainly if they were brought here, they cannot be held culpable for being brought here. So I would call anybody who came as a minor as a dreamer, right? Then we have a subsection of those dreamers, and those are people who received deferred action for childhood arrivals. That was the program created by the Obama administration. That's DACA. Those are people who had been here since 2007 and were here at least since 2007, who were here in 2012. They had to fit a very, very narrow set of criteria to be eligible for that program. And that allowed them to have a quasi-legal status. So they had deferred action, which is allowed under the Immigration and Nationality Act, which means they cannot be deported unless they lose their status. And they could lose their status by having a misdemeanor. So, any kind of crime would remove them from eligibility from DACA, or their DACA could be rescinded, but only for having that type of crime, such as a DUI or anything more serious than that. But those individuals now, we're talking about people who are in their late 20s, early 30s and beyond.
So if somebody came in as a dreamer under that definition, if they get married to a U.S. citizen, how does that affect us?
Well, it depends. So again, if they entered unlawfully, whether they were a child or not, they're not eligible to do an adjustment of status inside of the United States. They would still need to do to get their visas abroad. But if they had DACA before they turned 18, then they would never have been out of status, so that they would not have accumulated unlawful presence. So they could get their visas and come back. But there are some people who applied after the age of 18 and they did have unlawful status. So they would need that waiver. Then there was and this is really in the weeds, but there are some people who were able to travel. So people who had deferred action under the DACA program could travel for work or school if they could demonstrate a need to travel. If they traveled and came back on a parole, and they had to have a specific permission to travel and come back on that parole, they could adjust status because now they have what's considered a lawful entry. But these cases have shifted depending on the administration, depending on who the attorney general was. So under the first administration, they tried to change it to say, no, can't adjust status if you entered on this parole. And now you can, but I'm sure that will change. And again, it's just constant changing of circumstances. And I'd like to say something also, because there's something else that happened last week, which was that the Trump administration decided to freeze all applications for people who came in the last 4 years. So one of the questions I get quite frequently is, well, how is this going to affect the Cuban population? Because it's almost like they're kind of immune from any of these enforcement operations. And in fact, I believe in the law that was passed most recently by the state legislature and signed by Governor Ron DeSantis, is that there was an exception carved out for Cubans, whether they enter enter Florida without documents. But here's the thing: these are people who perhaps entered on parole, or they entered unlawfully at the southern border and then were granted a parole, and now we're applying for adjustment of status under the Cuban Adjustment Act. Those applications are being frozen to look for fraud, and so those applications are going to be on hold. So it will affect the Cuban population.
So let's say the application's on hold. So what does that mean for them until it's not on hold anymore?
Well, what it can mean, because remember, being in application does not actually give you legal status. Some people are under this misconception that, well, I've already applied for adjustment, so I have lawful status. No, when you're in application, you're actually not you're not accumulating unlawful presence, but you don't have legal status. So what it means is that you can still be detained, and you would have to have your your case heard in court. But if it's on hold, I don't know what that means, because if somebody's waiting, for example, if it's a Cuban Adjustment Act, for example, I don't know how the government intends to hold those cases if they're in court. So far, we haven't seen a directive come down for an adjustment of status in court. We're just seeing that the adjustments are frozen before USCIS, the Immigration Service. So it's really unclear.
Okay, let's talk about the folks that are in Homestead and working the fields down there. And if folks haven't been down there recently, you should take a look and see what kind of hard work that is. Generally speaking, the folks that are doing that, they're working for a farm-ish or maybe a subcontract. Those people typically would have a visa.
Yes.
And so right now, what does that mean for them?
So, I can't say that they would typically have a visa, actually. I think a large percentage have visas. They could have what's called an H-2A visa for agricultural purposes, or sometimes an H-2B, a temporary visa, a seasonal work visa as well. But it's temporary.
But when it's seasonal, what does that mean? They come for 3, 4, 5 months and then they go back home.
Yes.
And then they could come back theoretically if they could get through the border.
Well, they come back. Some of these people they go home and then they come back when it's the next season. So sometimes with agriculture, it doesn't need to be seasonal, so they can switch from they can follow the crops seasonally. Depending on their circumstance. But there's this other need for immigrants in the agricultural industry that isn't directly related to agriculture. So, for example, a lot of these large agricultural companies actually house and feed the immigrants that they have that are on those H-2A visas. So how do they house and feed this large number of immigrants? Well, it's with other immigrants, and that is typically through an H-2B visa, because that does not count as agriculture. So there's the seasonal or temporary work visas that are available.
Are they going to be gone also?
I can't say. I can't say. I think everything is on the chopping block, but I doubt this administration would make that grave of a miscalculation, because without those workers, we would have no food.
Let's talk about Venezuela. Very outspoken, very assertive in wanting to be here, very active in the community, and again, built morale, and it's terrific. Where are the other pockets of Venezuelans?
Well, there's also a huge population of Venezuelans in Weston. And actually, interestingly enough, from my hometown in Katy, Texas.
Wow.
Yeah. That's not Florida, but
the conservative folks down there must be pulling their hair out.
Well, so where Houston is a major petroleum industry that resides there, and Katy is a suburb of Houston where a lot of Venezuelan immigrants or non-immigrants decided to settle. And it's just interesting that now that's my hometown, and now I live in the number one city for the Venezuelan diaspora.
So let's say, what does all this look like in 6 months to a year?
Litigation. Honestly, that's what it looks like. Litigation.
Does that like put stuff on hold?
It does. It depends on the injunctions that are issued by judges. So the first part of the legislation would be filing for an injunction and putting these decisions on hold. But so far, we haven't seen that any judges have put this decision regarding the April 6th end of the 2023 extension of TPS on hold.
We should sort of hurry, no?
I think that one is a little bit, it's complicated administrative law procedure, but I know these lawsuits are in place, and again, I think the biggest difficulty for the migrant community and also for immigration attorneys and the community at large is the uncertainty. It's really the uncertainty because we just don't know where we're going to be. I think that's the hardest thing to navigate as humans is just the level of uncertainty that we experience.
So you're very passionate about this.
Yes.
Is it crazier it got the more passionate you became?
It's an unfortunate reality, but yes, just because I think that the craziness of it is what makes us more passionate because it's the injustice of it. It takes away our ability to plan. It takes away our ability to give, as an immigration attorney, find options and solutions. It is literally, constant whiplash. Things are changing so quickly that I can only give my clients advice from today and let them know that it can change tomorrow.
So with TPS, what in those numbers we hear, does that include the children?
Yes.
And that's like all ages or only over 18?
No, all ages,
all ages.
Of children could
so
have
these
TPS.
Kids, and let's say they're in junior high school, they hear this stuff and they see it. And they may not read it, but they certainly have seen it someplace. It must be pretty disruptive for these kids, thinking I've been here my whole life and I may have to go somewhere else.
Yeah, and I imagine they hear their parents talking about it as well. And I just imagine the amount of trauma and psychological harm that a child may be experiencing with this level of uncertainty as to their future. But it's not just the TPS recipients. I want to remind you that there are a lot of mixed status families where there are children with parents who are undocumented and who are facing the very real threat of deportation. And these children don't know whether they will be U.S. citizen children, by the way, that don't know whether they will be sent to a country they have never been to.
So if a family gets picked up, let's say they take the mom and dad and the kids, where do they go? Where's the facility until they're exported, if you will?
Well, there are residential detention facilities. If they're together, the children will either go with the mother or the father, but they can't stay together as a family unit because men and women cannot be housed together.
So a couple of years ago, when something similar took place, we saw those god-awful pictures. I know that you have to have some wall, but it looked like a jail, and essentially it is. But many of those kids wound up getting separated from their parents.
Yeah.
And there were some that they never found their parents, or vice versa.
Well, what happened in that particular case is actually when families came across the border, they were separated out. And so rather than what had happened in prior administrations is, again, the families would be held in a residential facility together, either the children with the mother or the children with the father. Typically, if it was a child and a father, they would be released because there's not a lot of residential facilities that accommodate men with children, I think for reasons we can imagine. And so the children would often be housed with the mother. But what happened under the first Trump administration is rather than house women and children together, they separated the families completely. Yeah.
Or Kelley, we're looking forward to you hosting your own show starting in March. All right.
Okay.
You're going to be right over here. You're going to do a wonderful job. Let's look at the red camera, because we're going to say, folks, thanks for joining us. Remember, take care of yourselves and your family. Have a good day.